healthcare providers in such regulatory actions such as this. I know a lot of you have been frustrated about the no surprise billing rules, so hopefully we can clear up some of the misunderstanding that's going on. You should have received a link to the written materials for the program today, in addition to the PowerPoints. Among those written materials, I issued a client alert a few weeks ago on the no surprise billing rules that provides a checklist that I understand has been helpful for people. So I recently updated that over the last week just to make sure that it's got some updated guidance that we've received. If you haven't looked at that yet, then obviously I'm biased, but you may want to call that up because I think that it can be helpful in understanding the no surprise billing rules. In addition, we've given you links and the materials themselves from the no surprise billing rules, including the Part 1 commentary and rules themselves, as well as some FAQs. We've also given you information concerning the Part 2 of the rules, including FAQs guidance that CMS has issued. I'll be talking a little bit later about the links to those so that you can access those and make sure that you have the current information. I know that a lot of people are frustrated with the no surprise billing rules, but they're really not as bad as you might think. It helps to understand the rules if you go back to look at the issues that Congress was trying to address. Congress was concerned about situations where patients get surprise medical bills in two contexts. The first is where you have an uninsured or self-pay patient. For purposes, I'll just refer to these as self-pay. So the first one is if you've got a situation where you've got an uninsured or self-pay patient that receives an unexpected medical bill, or that's much higher than they thought that it would be. In addition, the government was concerned about situations where an insured patient receives an unexpected medical bill from an out-of-network provider or facility. So this is a situation where the patient goes to a facility, they thought they were within network, only to receive a bill from an out-of-network provider that may be substantially in excess of what they thought they were going to owe. They were concerned about this in especially two situations. The first is where there's emergency services that are rendered by an out-of-network facility or provider, or if an out-of-network provider at an in-network facility bills separately from that facility. Now, these out-of-network rules are limited to just those two situations, situations where emergency services are rendered by an out-of-network facility or provider at an emergency facility. Or if you've got certain non-emergency services that are rendered by an out-of-network provider at certain healthcare facilities, not all healthcare facilities. We'll talk more about that in just a minute. In order to address these two concerns, the government came out with the no surprise billing rules. The rules actually implement the No Surprises Act. There's two portions of it. The first portion deals with insured patients with those out-of-network situations. The second deals with the self-pay patients. With the insured patients, it limits the amount that the out-of-network provider or facility may bill the patient and the payer for emergency services at an emergency facility or non-emergency services that are rendered by an out-of-network provider at an in-network facility. And it also applies to air ambulance services, but I'm really not going to talk about the air ambulance services today. So the first part of that rule is it limits the amount that providers can get paid. In addition, it requires the providers and the facilities to provide certain notice of these rights or these limits to the patients. It also sets up an independent dispute resolution process or IDR process by which the out-of-network provider or facility can determine the out-of-network rate that is going to be paid by the payers. Those are the general overview of the rules for insured patients. Well, what about the uninsured or the self-pay patients? Well, in that rule, the government says that the providers and facilities must give the patient a good faith estimate of their charges. If those charges come in substantially in excess, the actual charges come in substantially in excess of the good faith estimate, then the patient can initiate an SDR. It was the Selected Dispute Resolution, now known as the Patient Provider Dispute Resolution process or PPDR process, to determine the amount that that patient has to pay. In addition, the law or the rules require that the providers give the patients notice of these rights to limit their no surprise billing rules. So that's what we're going to talk about today. Today we'll talk first about the insured patients rules, and then second we'll talk about the self-pay patients. Well, what are the penalties for noncompliance? Well, the most immediate penalty is you may get a reduction or denied payment for the services that you rendered. So if it's an insured patient, you may be limited or denied payment because you can't balance bill the patient, or you're limited in the amount that you're going to get back from a payer if you're out of network. For self-pay patients, you may be limited or denied the PPDR process if the amount comes in substantially in excess of the good faith estimate that you provided to the patient. Now, those are the most immediate consequences. In addition to that, the No Surprises Act states that states are primarily responsible for enforcing that. So states are supposed to come up with a process for enforcing that. I don't think many states out there have come up with that process yet, so we have to watch that. But the No Surprises Act has kind of a catch-all that if the state fails to enforce these rules, then HHS may step in and they could impose a corrective action plan and or a civil penalty of up to $10,000. So it may be that you feel like, well, we don't really care about the IDR process or the SDR or PPDR process. We're just not going to worry too much about that. So we're not going to worry about compliance. Well, even if you're not worried about losing out money because of those processes, you still could get hit up with these civil monetary penalties. And therefore, you should consider complying or going through establishing the policies and procedures you need in order to comply. Even if you're not concerned about the patient or the payer coming after you, you should be concerned about potentially the government coming after you. If the state fails to do so, then the federal government could come after you and impose those penalties. All right, let's talk first about the rules for insured patients. This is really important. These rules for insured patients only apply in very limited circumstances. They only apply to out-of-networks or providers or facilities when they render emergency services at an emergency facility, and they apply to non-emergency services that are provided by an out-of-network provider at an in-network healthcare facility. Now, the types of facilities differ depending on these two situations. So when you're talking about emergency services, these out-of-network rules, the no surprise billing rules, only apply to emergency services that are rendered at an emergency department of a hospital or an independent freestanding emergency department as licensed by the state. So for this rule on the amount that you can bill for an out-of-network for services for emergency services, that only applies if you're rendering those services at an emergency department of a hospital or an independent freestanding emergency department if as licensed by the state. Now, some states may license urgent care centers as freestanding emergency departments, so it may extend there. But if not, then it only applies in those cases where these emergency services are rendered at an emergency department of a hospital or an independent freestanding emergency department. So the emergency rules, the emergency services rules, only applies at those facilities. On the other hand, the non-emergency services, the rules concerning non-emergency services, only apply if an out-of-network provider renders these non-emergency services at an in-network healthcare facility. For purposes of this rule, a healthcare facility is a hospital, hospital outpatient department, critical access hospital, or ASC. So if you're an out-of-network provider, but you're not rendering emergency services at an emergency department of a hospital or an independent freestanding emergency department, or if you're an out-of-network provider, but you're not rendering non-emergency services at a hospital, hospital outpatient department, critical access hospital, or ASC, then you really don't need to worry much about these rules. These rules simply won't apply in your situation. You will still have to worry about the self-pay rules, but we'll come to that in just a minute. So let's say that you are an out-of-network provider who is rendering emergency services at this emergency facilities or non-emergency services at these healthcare facilities, those that we specified. Then what does it say? Well, the first part of the rule, it places the limits on the amount that a patient is obligated to pay an out-of-network provider. Basically, it says that the patient's cost sharing for out-of-network services is going to be no higher than the in-network level that patient might otherwise have to pay. So for example, if the patient's cost sharing amount for in-network service is 20%, then the patient's cost sharing amount for the out-of-network service is also going to be 20%. Well, 20% of what? Well, the rule then sets forth the amount to which that cost sharing applies, which is defined as termed the recognized amount. That recognized amount is determined in descending order of the following. If you are in a state that has an amount that's determined by an applicable all-payer model agreement under the Social Security Act, then you would go by that amount. If there is no applicable all-payer model agreement, then then you would look at the amount that's determined by state law. If there is no state law limit on the amount that can be charged, then you would look at the lesser amount of either the billed charge or the qualifying payment amount, or the QPA. This QPA is all important when it comes to these out-of-network billing rates. The QPA, or the qualified payment amount, is generally the plan's median contracted rate in 2019 for the same or similar items or services provided by a similar provider in the same geographic region, adjusted by the CPI. So determine the amount that you can bill the patient is going to be, for most of you, the QPA, either the lesser of either the billed charge or that QPA for that amount. Now, the rules contain an exception that would allow you to balance bill a patient above that cost sharing limit, but only if you give written notice of, you provide certain written notice to the patient, and the patient gives you written informed consent that would allow you to bill above those cost sharing amounts. Now, even though the rules allow you to do this, how many patients do you know would say, yeah, okay, I know I only have to pay this much, but I'll go ahead and pay a lot more than that. I'll allow you to balance bill me. That's not going to happen that often. And so even though there is this option for getting the patient's consent, it's pretty difficult to do because of all the information that you have to provide the patient, the steps that you have to jump through. But nevertheless, there is a process that if you wanted to, and the patient were willing, you could get permission to go ahead and balance bill above the amounts that are set by the no surprise billing rules. But in order to do that, you've got to give the patient the appropriate notice, and then you've also got to give the patient consent. In the materials I provided to you, it walks through that in more detail. Now, even though there is this exception to allow you to get the notice and consent, there are certain circumstances in which the patient cannot waive, and you are limited. You can't balance bill in these situations. You can't get the patient's consent to balance bill in these situations. This would include unforeseen urgent medical needs that arise at the time the services are rendered. You can't ever balance bill, or the patient can't waive those because you never had the opportunity to provide advance notice, and the patient could never consent to it because they were urgent situations that arose. So the government has carved that out, said, no, you can't ever waive that. In addition, pre-stabilization emergency service, same kind of thing. In those situations, the government assumes that that patient can't get advance notice and can't really waive it because it's an emergency situation, and therefore this notice and consent option to waive those limits on balance billing doesn't apply to these pre-stabilization emergency services. And even in non-emergency services, the government has said we're not going to allow the patient to waive, and they can't consent to balance billing for certain types of services, including certain ancillary services that are provided in non-emergency situations like anesthesiology, pathology, radiology, neonatology, assistant surgeons, hospitalists and intensivists, diagnostic services, including radiology and labs, and as well as items or services that are provided by an out-of-network provider if there is an in-network provider who can furnish them at the facility. These are just situations where those caps are always going to apply and the patient can't waive it. If you are successful in getting the patient to waive and can allow you to balance bill, then you've got to provide that notice to the insurer because that affects the amount that the insurance may pay. In order to make sure that the patients are aware of these rights, you've got to publish a notice of the patient rights. The government has issued a form that you can use in providing that notice. You've got to post that notice on the website. In addition, you've got to post the notice on a sign prominently displayed in your facility, and you've got to give that notice to patients in person or by mail, in person and you've also got to provide by mail or email as determined by the patient. So if you want to use that, seek those. Well, any patient actually is entitled to that notice. So you've got to make sure if you're a facility that you're providing that notice. If you are a provider who never renders those services at those types of facilities, then you don't need to worry about it. But if you're a facility, then you're going to want to be providing. If you are going to seek the patient's consent to balance bill above the regulatory limits, then the government has provided the forms that you need in order for the patient to effectively waive that. Among other things, that notice and consent has to contain, it's got to identify, give the patient advance notice that you are out of network. You've got to provide a good faith estimate of the charges the patient is going to pay. You've got to give, it's got to state that the notice is not a contract, so the patient understands that they're just by getting that notice that they don't, that they're not necessarily bound by it, and that their consent is optional. They're not obligated to agree to it. And you've also got to advise them, the patient, that they have the right to receive care from an in-network provider. And then you've got to provide certain information about the services. Again, if you want to go that route and you want to balance bill the patient above these limits that are set by the rules, then you need to fill out that form, give that form to the patient. All right, those are the rules for the amount that you can bill the patient and the limits on your ability to balance. What about getting paid by the payer? Well, the no surprise billing rule places a cap on the amount, or at least establishes limits on the amount that the payer is obligated to pay an out-of-network provider or facility. That amount, including any cost-sharing amount, is determined by the following in kind of a decrease in order of hierarchy. So first, if there's an amount that's determined by the applicable all-payer model agreement then if that's in place, then you would go by that amount. If there's no applicable all-payer model agreement, then you would look at the amount that's determined by state law. If neither of those apply, then you would look at an amount that's agreed upon by the payer and the provider during this 30-day open negotiation period. So if there's no all-payer model or no state law that establishes that amount, then the parties will have an opportunity to negotiate the rate that payer is going to pay during this 30-day open negotiation period. If they're not able to reach agreement, then either side may initiate the IDR process, and the amount that's going to be due is going to be determined by that IDR process. In order to initiate that IDR process, first you have to give notice that you want to initiate the open negotiation period. So within 30 days after you as a provider receive the partial payment or a denial from the payer, then you've got to send them a notice within 30 days starting that open negotiation period. That notice has to contain certain information that's required by the rules. The Department of Labor has actually issued a sample open negotiation notice that you can use in providing that to the payer. So you would email or send that to the payer. And that triggers the 30-day open negotiation period. So the parties attempt to resolve the matter during that 30-day open negotiation period. If the parties are not able to reach agreement during that 30-day open negotiation period, then either party, either the payer or the provider, is going to request the IDR by filing a written notice within 4 business days after the 30-day open negotiation period ends. You can't request the IDR during that open negotiation period. You have to wait for that 30-day period to run, and then you've got 4 days in order to initiate the IDR process. You initiate that IDR process by submitting the appropriate notice. Again, the Department of Labor has published a form that you would submit to the payer, as well as providing notice to the government, and that will trigger the IDR process. Within 3 business days after the IDR is initiated, the parties may agree or object to the IDR entity. So the government has contracted with certain entities to serve as kind of the arbitrators in these IDR process. So you can, the provider and the payer can try to agree on who that IDR entity is going to be. And 4 days after the IDR is initiated, the initiating party must notify HHS of the IDR entity if the parties agree. If the parties don't agree, then you've got to submit those objections within the period, the 4-day period. Within 6 days after the process is initiated, if the parties haven't agreed, then HHS will simply appoint the IDR entity. It's usually in the party's best interest to try to agree on the IDR entity that they want, because the IDR entities can charge a fee within a certain range. And if you don't agree on who's going to serve as the IDR entity, then you may get stuck with an IDR entity that's going to charge a higher fee. The parties must then pay the IDR administrative fee that's set by HHS. It's a standard fee that HHS sets, so both parties have to pay that. If the parties agree on the out-of-network rate while the IDR is pending, they've got to notify HHS within 3 days, which will terminate the IDR process, of course. Once that IDR entity is selected, then within 10 days, each party will submit their out-of-network rate offer. So the way that this works is, this is baseball arbitration. So each party selects kind of their best offer. And then the arbitrator, the IDR entity, selects which of those offers they're going to accept. When you submit that information to the arbitrator, you submit that information both in a dollar amount and a percentage of the QPA. You can also submit the additional information that's requested by the IDR entity. If you are a provider, you can also submit additional information as appropriate that may justify a rate that's different than the QPA, such as the size of the practice or facility, the practice specialty, the QPA for the applicable year for the same or similar item or service, and you can submit any additional information that you believe is appropriate. There's certain information that is not appropriate that you can't submit, and that it's not really relevant, at least according to the regulations. So you go ahead, you submit this information to the IDR entity. When the IDR entity makes its determination, it doesn't come up with its own number, right? It selects either of the amounts that are selected by the parties. So it selects the one that it believes is appropriate under the circumstance. It doesn't split the baby. The IDR entity doesn't split the baby or come up with its own. So it behooves you to try to submit the one that is most reasonable under the circumstances so that you can get yours selected. At the time you submit that information back to the IDR entity, both parties submit the IDR entity's fee. The winner ends up getting a refund of that. The loser ends up having to pay the IDR entity. Within 30 days after that IDR entity is selected, the parties have now submitted their information. The IDR issues the written decision selecting one of the offers based on the following factors: the QPA for the applicable year for the same or similar item or service, the any information that was requested by the IDR entity, any additional information that's submitted by the parties relating to, for example, so forth, their market share and the like, the factors that may affect or show that that QPA is not the appropriate number. In order for the IDR entity to consider those, the information must be credible. But beware of this, that under the regulations, the IDR process is skewed heavily in favor of the QPA. In fact, the commentary that accompanied the regulations state that the IDR entity must select the offer closest to the QPA unless the credible information submitted by the parties clearly demonstrates that the QPA is. The regulations themselves state that additional information that is submitted must clearly demonstrate that the QPA is materially different from the appropriate out-of-network rate, and the IDR entity has to justify their decision if they're not going to select the QPA. This is the provision that has really irked providers because it skews the process heavily in favor of the QPA. The QPA becomes the presumptive amount that the IDR entity is going to use. And the concern is that favors the insurer, because the insurer is the one who kind of determines what that is. Because of that, the AMA, the AHA, and others have sued HHS challenging that QPA presumption. That lawsuit is still pending. It's still moving forward at a snail's pace. It's unlike the COVID mandate that has been stayed or anything like that. So, we're still stuck with this interim rule in the meantime, while that challenge works its way through the courts. Well, once that IDR entity issues its decision, that decision is binding on the parties absent fraud or intentional misrepresentation. So it's not like you can just ignore it and go out and sue to recover additional amount. You're bound by that. It's not subject to judicial review. The party who initiated the IDR may not initiate a similar IDR involving the same party or same or similar claims for 90 days. So you can't, once you got that decision, you're kind of bound by that decision for all similar proceedings for a period of time. Within 30 days of getting that decision back, the loser has to pay any balance that may be due the other party, meaning that if the insurance company lost, then they've got to pay the balance due the other party. The loser remains responsible for the IDR entity fee, but the winner gets their prepaid fee refunded. So that is the IDR process. So for you as a provider, if you're an out-of-network provider, you want to go through this process. I guess the initial question is, is it worth the time or effort to you? Are you going to be able to establish that there is justification for not accepting the QPA? And now that is the presumptive amount. So those are some of the factors that you need to remember. Remember that only applies to certain limited circumstances. It's only going to apply if you are an out-of-network provider that renders emergency services at an emergency facility, which again is just an emergency department at a hospital or a freestanding emergency department, or you're an out-of-network provider that's rendering non-emergency services at an in-network facility, and those in-network facilities, again, those rules only apply to hospitals, critical access hospitals, ASCs, and the like. These rules that we just talked about don't apply to a lot of providers, if not most providers, including just physician offices, unless they're otherwise rendering services at those other facilities. Now, in contrast to those out-of-network rules, the rules concerning self-pay patients apply to all healthcare providers. So or essentially all healthcare providers. So if you were blanking out on the other stuff, it's time to perk out and pay attention. Under these rules, a convening provider or facility, and by convening provider or facility, that's just the provider or facility who is responsible for scheduling and initiating the patient care. A convening provider or facility must determine if a patient is uninsured or a self-pay individual. For purposes of our discussion today, I'm just going to refer to them all as self-pay individuals. In order to do that, you've got to ask if the patient is covered by a group plan, insurance, or a federal healthcare program. If they are, then they're generally considered insured, not uninsured or self-pay, unless if the patient has coverage and they don't want to submit the claim. In that case, they would be a self-pay patient. So you ask the patient if they're covered by a group plan, insurance, or federal healthcare program, or if the patient does have coverage, ask if the patient wants to have the claim submitted to the payer for the primary item or service. If they do want to submit the claim, then they're insured and you don't have to walk through the self-pay process. The self-pay rules won't apply. But on the other hand, if they're not, if they're uninsured or self-pay, then you've got to jump through the self-pay hoops. So if the patient is a self-pay, you have to inform the patient that they may obtain a good faith estimate of the expected charges upon scheduling the item of service or upon the patient's request. A convening provider or facility must inform the self-pay patients about their right to a good faith estimate, and they do it in several ways. First, you've got to publish a written notice that's prominently displayed on your website, in your office if you have a physical office, and on site where scheduling or questions about the cost of items or services occur. So you've got to post the notice. In addition, you've got to orally inform the patient when that patient is scheduling an item or services, or when the patient asks about the cost of items or services. The regulations expressly state that the patient is entitled to a good faith estimate if they request one, and the regulations interpret that to mean that if the patient asks about costs, then they are requesting a good faith estimate, so you would have to provide a good faith estimate. That notice of the patient's right has to be made available in accessible formats and the language spoken by the patient. So the non-discrimination rules apply here. So if you have, for example, a person who speaks Spanish, and then you may have to give that notice, and both the oral and the written notice in Spanish. If they are hearing impaired, then you may have to make sure that you satisfy your discrimination obligations, anti-discrimination obligations, to provide that in a manner that can be understood by the patient. HHS has published the form that you should use for self-pay patients, that notice. This is the notice that you would post on your website and make available to the patient, provide. If the self-pay person requests a good faith estimate, including asking about the discussion of costs or upon scheduling a primary item or service, then you've got to provide the good faith estimate. So first, you've got to give them notice. And so if the patient then requests a good faith estimate or asks about the cost, or if you schedule a primary item or service, then that convening facility or provider must provide that good faith estimate. In addition, under the Act and under the rules as they currently exist, within 1 business day of getting that request or the patient's asking about the cost, you as the convening facility or provider would have to reach out to co-providers or facilities, so others who are also involved in the patient's care and who are not part of you. You would have to reach out to them to get a good faith estimate so that you can obtain a good faith estimate from that other entity their charges, so you can include that in your good faith estimate. Now, even though that's in the rules, the government has said that they are not going to enforce those rules concerning co-providers during calendar year 2022. You've got enough to worry about just as a convening provider in providing these services, so you don't need to worry about this during calendar year 2022. Come 2023, unless they change the rules, then you are going to have to collect that information from co-providers. If you're a co-provider, you're going to have to be providing that information, but for calendar year 2023, you don't need to worry about it. Right now, convening providers just need to worry about providing the good faith estimate for the services that they themselves are providing. And you've got to provide that good faith estimate in a timely fashion. The rules set forth the timelines. If the item or service is scheduled at least 3 days in advance, you've got to provide that good faith estimate not later than 1 business day after the date of scheduling. If the item or service is scheduled at least 10 days in advance, you've got to provide the good faith estimate not later than 3 business days after the date of scheduling. If the patient requests a good faith estimate, you've got to provide that good faith estimate not later than 3 business days after the date of the request. If the patient requested good faith estimate and then schedules the services, then you would default back to see above. You must provide that new good faith estimate within the timeframes described above. If there's any change to the anticipated charges, so in the process of this, maybe you come in, you see the patient, you identify, well, they've also got these additional concerns that have to be addressed. If there are any changes, you must provide an updated good faith estimate no later than 1 business day before the items or services are scheduled to be rendered. So you've got to provide those services within those. Now, that raises the question, probably the question I've received the most under these rules. Well, what happens if we're an urgent care center, or we don't schedule those services 3 days in advance? We provide them immediately, or they show up at the emergency department. What about those situations? How do we deal with those? We don't have a lot of guidance on that, but the commentary and also the FAQs contain the following. The HHS acknowledges that there are some items or services that may not be included in a good faith estimate because they are not typically scheduled in advance and not typically the subject of a requested good faith estimate, such as urgent, emergent, trauma, or emergency items or services. However, to the extent that such care is scheduled at least 3 days in advance, a provider or facility would be required to provide a good faith estimate. How does that work? I think what that means is if the patient comes in to receive those services at an urgent care center and the like, and they want to receive them less than 3 days in advance, you don't have to do the good faith estimate, okay? On the other hand, if the patient comes in, even if you're an urgent care center, you typically provide those services immediately. If the patient still comes in and they want to find out what you charge and they request a good faith estimate, then you would still need to go ahead and provide that good faith estimate to them for services that they might want to get sometime in the future. I think that's what it means. That's consistent with the guidance that they gave. HHS went on to state that, for example, individuals will likely not be able to obtain good faith estimates for emergency air ambulance services, as these are not generally scheduled in advance. However, making these requirements applicable to providers of air ambulance services helps to ensure that individuals can obtain a good faith estimate upon request or at the time of scheduling non-emergency or ambulance services. We haven't got, again, much guidance concerning this, but I think what that means is even if you're an urgent care center, emergency department, you still got to post your notices and you'd still have to provide a good faith estimate if the patient comes in there and asks for one, even if though you typically do not schedule those services in advance. I think that that's what it means, and that would be consistent with the language in the Act. The rules do provide for situations. Well, you may have a situation where what happens if we provide the same service to the patient on a repeated basis? Does that mean we have to provide a good faith estimate every time we see the patient or every time we schedule their next visit? The government has said, no, the convenient facility may issue a single good faith estimate for recurring primary items or services if such good faith estimate includes in a clear manner the scope of the recurring services, such as time frames, frequency, total number, etc. The scope of the good faith estimate may not exceed 12 months, so you can do this recurring good faith estimate for a period of up to 12 months. If the recurring items or services extend beyond that 12 months, you must provide a new good faith estimate. If the convening providers or facilities that are listed in the good faith estimate change less than 1 business day before the item or service is scheduled to be provided, the replacement provider, the substitute, must accept the existing good faith estimate as its good faith estimate, and they're going to be bound by that good faith estimate. So let's say, for example, you're going to be assuming the care of a particular patient, 1 day before the scheduled service. In that situation, you're going to be bound by the good faith estimate that your predecessor gave. So you may want to consider whether or not you want to take on that case, or review the good faith estimate in advance to determine whether or not you want to take that out. Or you may want to reschedule that case for later on so that you can provide your own good faith estimate in more than 3 days and comply with those rules. Otherwise, you're going to be bound by the good faith estimate that was. That good faith estimate has to satisfy certain criteria. As you all know, as you're trying to implement this, the regulations are pretty specific concerning, and very detailed about the information that you've got to provide. It's got to include the patient name and birth date, items and services by codes and charges, discounts or adjustments, the name, NPI, TIN of co-providers or facilities, at least perhaps not now, but we'll see. The location where each item or service is provided, the list of items or services that will require separate scheduling, and a long list of disclaimers that have to be included. For good or bad, the government has issued a form, good faith estimate. You're not necessarily required to use this form, but your good faith estimate has to contain the elements that are included in the regulations and presumptively reflected in that form. You're going to want to make sure that that good faith estimate is accurate and complete, because you are likely going to be bound by it, either as a matter of contract. The patient could say that this was a contract, even if, unless you have appropriate disclaimers. Alternatively, if the actual charges come in substantially in excess of that good faith estimate, then the patient has a right to initiate the PPDR process, which would determine the amount that the patient actually has to pay. We'll talk about that. In providing that good faith estimate to the patient, that good faith estimate has to be in writing and given in a manner requested by the patient. That means either paper or electronically, so long as it's provided in a form that the patient may save and print. But the patient has the right to determine the form that they get. If the patient requests it orally, you've got to provide it orally, but you still have to provide it in writing also. That good faith estimate has to be provided in a manner understandable to the patient, considering their vision and hearing, language limitations, including their limited English proficiency, communication needs of underserved populations, and health literacy. So it may require you, again, like other significant transactions, to consider your obligations to provide interpreters, translators, auxiliary aids, or so forth. Once you create that good faith estimate, it becomes part of the patient's medical record, and the regulations state that it must be maintained in the same manner as the medical record. You've got to provide that good faith estimate to the patient if they come back and want a copy of that for up to 6 years. that means that you would apparently that you're going to have to maintain that good faith estimate for 6 years so that you can provide, you have it available if the patient comes back and requests that. Well, what happens if you haven't got all the information or you make errors in the good faith estimate? As far as compliance and getting hit up with that $10,000 penalty, the government has said that errors are not necessarily non-compliance so long as you acted in good faith with reasonable. What about if your good faith estimate includes information from a co-provider, but the co-provider was wrong? Again, the government said you're not liable for that. That's not non-compliance so long as you did not know and should not have known of the error, and you correct the information as soon as practicable. But that doesn't mean that you get around the PPDR or the SDR limits. You're still bound by that SDR or PPDR process if the actual charges are substantially in excess of the good faith estimate. Let's talk about that SDR process. Or if the total billed charges for the listed provider or facility are substantially in excess of the total charges on the good faith estimate, that means at least $400 or more than the patient may initiate the patient-provider dispute process. So if your actual billed charges are more than $400 or more than the charges, the actual charges, the actual bill charges, then the patient can initiate this. Determining whether it's substantially in excess, it's determined by the particular provider involved. So for example, if provider A provides services X and Y and provider B provides services Z, the self-pay patient may initiate this SDR process if the total charges for X and Y exceed A's good faith estimate for such services. So you look at and divide this by substantial in excess includes items or services that were not included in the good faith estimate. So if you didn't know that the patient needed something at a particular time or otherwise failed to provide that information, well, that still is considered in determining the amount in the good faith estimate. So if you simply failed to include something in the good faith estimate, you're still going to be bound by that $400 limit. That's going to be factored in the $400 limit. And then the question is going to be whether or not you satisfied the requirements, had a good reason for not including that in the good faith. To initiate that PPDR process, within 120 days of receiving the bill, the patient has to initiate that. They do so by contacting HHS through the bill and paying a $25 fee. The PPDR or SDR entity then determines whether or not it's appropriate for the SDR process. If they determine that it is appropriate, they will notify you. Once you get notice that PPDR process is pending, it acts as a stay on your ability to continue collections. It's kind of like the patient filing bankruptcy in a way. So while the PPDR process is pending, once you get that notice, you cannot move the disputed bill to collections or threaten to do so. If the bill has been moved to collections, you've got to cease collection efforts. You've got to suspend accrual of late fees on an unpaid bill amount, and you cannot take or threaten any retribution against the patient to obtain resolution of the dispute while this PPDR process is pending. Once you get notice that it's in that PPDR process, the SDR entity will notify you within 10 days of that notice. You've got to provide the following information back to the SDR entity if you want to challenge the amount that's due or challenge the, force the patient to pay more. You've got to provide a copy of the good faith estimate relevant to the dispute. You've got to provide a copy of the billed charges that are subject to the dispute. And if available, you've got to provide documentation showing that the difference between the billed charge and the good faith estimate reflects the costs of medically necessary items or services, and that those medically necessary items or services were unforeseen. There were unforeseen circumstances that could not have reasonably been anticipated by the provider or facility when the good faith estimate was provided. That is the relevant standard. You're going to be bound by the amount that was in that good faith estimate unless you can show that there were circumstances that justified you not putting the additional information in that good faith estimate and that those additional services were medically necessary. Within 30 days, the PPDR entity looks at these factors, that information we provide, and they go ahead and make their determination. If the billed charge, the way that this works, the determination is determined as follows. If the billed charge is listed on the good faith estimate, if the billed charge is less than or equal than the expected charge, then the patient pays the billed charge. If the billed charge is greater than the expected charge and the provider failed to prove medical necessity and unforeseeability, then the patient pays the expected charge from the estimate, no matter, even if more. If the billed charge was greater than the expected charge and the provider does prove medical necessity and unforeseeability, that doesn't mean that the provider necessarily gets the actual billed charges. Instead, the patient pays the lesser of the billed charge or the expected charge on the good faith estimate if the expected charge is greater than the median rate paid by a payer of the same or similar service by the same or similar provider in the geographic area as listed in an independent database, or the median rate if the expected charge is less than the median rate. Well, what about if the billed charge is not even listed on the good faith estimate? Well, in that situation, the provider failed to prove medical necessity and unforeseeability, and the patient pays zero for that additional item or service. They'd still have to pay for items that were included in the good faith estimate, not for that item that was not included. Provider proves medical necessity and unforeseeability. Again, the patient pays the lesser of the billed charge or the median rate paid by a payer for the same or similar service in the geographic areas listed in an independent database. So just because you throw out a billed charge there doesn't necessarily mean you're going to get what you. Well, the government is trying to make this information available to patients and alert them concerning their rights. They've got a government website for that. In a word about coordination with state laws, some of you may be in states that have more restrictive laws or greater consumer protection for patients. And so you may need to coordinate the no surprise billing rules with that state law, including issues concerning the notice, concerning the fees charged, the fees that may be charged, a dispute resolution process, or otherwise. In general, if and to the extent the state law provides less protection to the patients than the no surprise billing rules, then you apply the no surprise billing rules. If and to the extent the state law provides more protection to patients than the no surprise billing rules, then you generally defer to state law and you would apply the state law. So you need to make sure you understand what your state law rules are. All right. That is a relatively quick overview of the no surprise billing rules. The first part only applies to out-of-network providers for insured patients and only applies to providers rendering services at certain facilities. The second part deals with self-pay patients. Remember, self-pay patients for most of you is probably going to be a relatively small portion of your hospitals, and maybe 3 to 5% of your patients. So the self-pay rules, I know it's frustrating, but it's probably a relatively small portion of your patient population. You still have to jump through some of the action items, but as a practical effect, it may not be as bad as you may initially think. So some suggestions to make sure that you're on track for this stuff. You're going to want to confirm and coordinate your state law requirements, and where required, include those in your notices. You're going to determine if you're an out-of-network provider rendering services at facilities, or you're an out-of-network facility rendering emergency services, to determine whether or not these rules, the rules applicable to out-of-network providers, apply to you. Remember, they only apply to emergency services at emergency departments or freestanding emergency departments, and certain out-of-network non-emergency services provided by an out-of-network provider at an in-network facility. That's going to determine Part 1 relevance. If you don't provide services in those contexts, then you really don't need to worry about that Part 1 of the rule. If Part 1 does apply to you, then you have to determine if you're going to attempt to obtain the advance notice and consent from the patients in order to allow you to balance bill above. If you decide that you are actually going to do that, then you need to go ahead and put in place those processes that would allow you to get that. Spoiler alert, it's hard to do. I'm not sure it's worth the time and effort for most of you. You should also determine if and when you are going to initiate the IDR process for disputes with payers. Like I said, the QPA is the presumptive rule, and is it really worth it to you to go in there and challenge that? It may be that you determine that we haven't got enough to justify going outside the QPA, and therefore we're just going to accept the QPA amount. But you may want to consider kind of what the parameters are and decide whether or not it's worth it to you to fight those issues. You're going to want to create and implement appropriate forms, including the forms if you're going to bill for out-of-network services. You've got to provide the notice and consent to your patients. You may want to have an agreement with the facility to provide the patient rights of the notice. That you can enter into an agreement with the facility, so the facility. If you're going to engage in the IDR process, you're going to want to make sure that you've got the right forms and use the right forms to initiate the 30-day open negotiation period and to initiate the IDR at the close of the open negotiation period. Those are available from the Department of Labor. You're going to want to maybe come up with forms that justify the rate offer, and certain appropriate factors you can throw in there that would justify going above the QPA. You may want to develop those so that you can use those when you go through this process, as well as identifying additional supporting criteria. For the good faith estimate, you're going to want to make sure that you've got the appropriate forms that would allow you to provide that good faith estimate, as well as the notice of the right for the patient to receive the good faith estimate. You may want to establish an estimate for standard procedures so that you've got it on hand, because you haven't got a lot of time to pull these things together. So you may want to come up with a template for good faith estimates that you can use on a regular basis, so that you can provide those. If you are going to go through the PPDR process, you may want to come up with the documentation you need that would justify going through that PPDR process, including addressing things like unforeseen circumstances and the like. You want to obtain and prepare the required notices, including posting those notices of the patient's rights concerning balance billing. All of the facilities, if you're a facility, an emergency facility or a hospital or access hospital or ASC, you're probably going to want to post all of those, whether or not you decide to pursue the balance. All providers and facilities are going to want to post the notice of the patient's rights. You have to publish those required notices, so you can obtain those notices from the government's website that we'll talk about in just a minute. You've got to publish those required notices on your website, in the prominent location in your office or facility, a physical location, the location where billing questions are discussed. And you're going to have to make sure that those notices comply with the language and accessibility requirements, including that they're easily understandable, translated into relevant languages, depending on your location, that you have available interpreters and auxiliary aids in order to make those notices. You're going to want to process the calendar for the IDR process to make sure that you hit those deadlines. There's a quick summary of the deadlines that you need to meet. You're going to want to develop and train your staff concerning the relevant processes, concerning the IDR process. Process for self-pay patients. So particularly with regard to self-pay patients, you're going to want to train your staff to, when patients show up, to determine whether or not the patient is self-pay. Train them to advise the patient of their right to receive a good faith estimate. You're going to generate that good faith estimate. Again, it may be helpful to have templates in your database. You're going to want to, effective 2023, unless the rule changed, have a process in place to obtain that estimate from the co-providers. You're going to want to provide the estimates to the patients in a timely manner, update those estimates as appropriate. If you're a replacement provider stepping in, you're going to want to review and update the estimate to the extent you can, otherwise you're going to be bound by it. And then you need to make sure that you've got a process in place for maintaining that good faith estimate as part of the patient's. Going to get involved in the SDR process or the Now, remember that these all issued as interim final rules. So the government's still, they're binding on us in the meantime, but the government's still working on the final rules. If you want to submit comments, then you can go ahead and submit those comments. I believe that the deadline is still December of 2022. So if you really hate this stuff, there's your chance to Also, stay tuned. The government is periodically issuing additional guidance. They have updated some of their forms from the initial forms that were submitted back in September. So you may want to look for the final rules following comments. I think that there will be changes between now and 2023, but no guarantees. So you're going to want to make sure that you watch for additional potential changes, including rules that may affect your obligation to get good faith estimates from co-providers. Watch for other regulations implementing other portions of the Act. Right now, this good faith estimate only applies to uninsured or self-pay patients. The No Surprises Act requires a similar notice to be provided to insured patients and payers, but we don't have the regulations yet on that. So we'll have to watch for that as that. Additional resources. I've mentioned this several times, but the government has posted a lot of help on this website that shows up there on your screen. You can go to that website and it's got links to copies of the actual rules, to fact sheets that were published that kind of provide a summary, specific guidance concerning aspects, the IDR and SDR process. They've got helpful FAQs that talk about the scope of the rules and their application. Perhaps most importantly, this is where you can go to get the updated government versions of the forms and notices. For most of these, you are not required to use the government forms and notices, but quite frankly, I'm not sure why you wouldn't want to. You're probably safer if you do use those forms and notices. If you're going to go your own way and use your own form and notice, you better make sure you look at the regulations to ensure that you're actually complying with those. Some of these forms were created by the Department of Labor, particularly the notices concerning the SDR. So you could also go to this link, this website to get those. Those are actually also linked at the CMS website. You can, that'll also. States are also starting to roll out guidance and consumer protection. For example, here in Idaho, we've got a website dealing with those issues that provide additional links and additional guidance. CMS has provided additional help along the way. And there you go. There is some help. We do have additional resources on our website, including free client alerts, the client alerts that I've sent out so far on the No Surprise Billing Rule, those site, as well as webinar recordings. This program is recorded and we'll post it there on the webinar in case you or anybody else wants to listen to it. Other than that, that is it. If you have any questions, by all means, shoot me or Allie an email and we'll try to answer it offline, or you can submit it using the chat feature and Luke will get those questions that were submitted using the chat feature over to me and I'll try to respond. There we go. Good luck with you all and thanks so much for participating today.